Minnesota v. Carter, Supreme Court, 1998. Chief Justice Rehnquist delivered the opinion of the court. Respondents and the lessee of an apartment were sitting in one of its rooms bagging cocaine. While so engaged, they were observed by a police officer who looked through a drawn window blind. The Supreme Court of Minnesota held that the officer's viewing was such that violated respondents' Fourth Amendment rights. We hold that no such violation occurred. James Thielen, a police officer in the Twin Cities suburb of Eagan, Minnesota, went to an apartment building to investigate a tip from a confidential informant. The informant said that he had walked by the window of the ground floor apartment and had seen people putting a white powder into bags. The officer looked in the same window through a gap in the closed blind and observed the bagging operation for several minutes. He then notified headquarters, which began preparing affidavits for a search warrant while he returned to the apartment building. Two men left the building in a previously identified Cadillac. The police stopped the car. Inside were respondents Carter and Johns. As the police opened the door to the car to let Johns out, they observed a black zippered pouch and a handgun, later determined to be loaded, on the vehicle's floor. Carter and Johns were arrested, and a later police search of the vehicle the next day discovered pagers, a scale, and 47 grams of cocaine in plastic sandwich bags. After seizing the car, the police returned to apartment 103 and arrested the occupant, Kimberly Thompson, who is not a party to this appeal. A search of the apartment pursuant to a warrant revealed cocaine residue on the kitchen table and plastic baggies similar to those found in the Cadillac. Thielen identified Carter, Johns, and Thompson as the three people he had observed placing powder into baggies. The police later learned that while Thompson was the lessee of the apartment, Carter and Johns lived in Chicago and had come to the apartment for the sole purpose of packaging the cocaine. Carter and Johns had never been to the apartment before and were only in the apartment for approximately 2.5 hours. In return for the use of the apartment, Carter and Johns had given Thompson 1/8 of an ounce of the cocaine. Carter and Johns were charged with conspiracy to commit a controlled substance crime in the first degree and aiding and abetting in a controlled substance crime in the first degree in violation of Minnesota statutes section 152.021. They moved to suppress all evidence obtained from the apartment and the Cadillac as well to suppress several post-arrest incriminating statements they had made. They argued that Thielen's initial observation of their drug-packing activities was an unreasonable search in violation of the Fourth Amendment, and that all evidence obtained as a result of this unreasonable search was inadmissible as fruit of the poisonous tree. The Minnesota courts analyzed whether respondents had a legitimate expectation of privacy under the rubric of standing doctrine, an analysis that this court expressly rejected 20 years ago in Raucus. The Fourth Amendment protects persons against unreasonable searches of their persons and houses, and thus indicates that the Fourth Amendment is a personal right that must be invoked by an individual. But the extent to which the Fourth Amendment protects people may depend upon where those people are. We have held that capacity to claim the protection of the Fourth Amendment depends upon whether the person who claims the protection of the amendment has a legitimate expectation of privacy in the invaded place. The text of the amendment suggests that its protections extend only to people in their houses, but we have held that in some circumstances, a person may have a legitimate expectation of privacy in the house of someone else. In Minnesota v. Olson, 1990, for example, we decided that an overnight guest in a house had this sort of expectation of privacy that the Fourth Amendment protects. In Jones v. United States, 1960, the defendant seeking to exclude evidence resulting from a search of an apartment had been given the use of the apartment by a friend. He had clothing in the apartment, had slept there maybe a night, and at the time was the sole occupant of the apartment. But while the holding of Jones, that a search of the apartment violated the defendant's Fourth Amendment rights, is still valid, its statement that anyone legitimately on the premises where a search occurs may challenge its legality was expressly repudiated in Raucus v. Illinois. Thus, an overnight guest in a home may claim the protection of the Fourth Amendment, but one who is merely present with the consent of the householder may not. Respondents here were obviously not overnight guests, but were essentially present for a business transaction were only in the home a matter of hours. There is no suggestion that they had a previous relationship with Thompson or that there was any other purpose to their visit, nor was there anything similar to the overnight guest relationship in Olson to suggest a degree of acceptance into the household. While the apartment was a dwelling place for Thompson, it was for these respondents simply a place to do business. Property used for commercial purposes is treated differently for Fourth Amendment purposes from residential property. An expectation of privacy in commercial premises, however, is different from, and indeed less than, a similar expectation in an individual's home. And while it was a home in which respondents were present, it was not their home. If we regard the overnight guest in Minnesota v. Olson as typifying those who may claim the protection of the Fourth Amendment in the home of another, and one merely legitimately on the premises as typifying those who may not do so, the present case is obviously somewhere in between. But the purely commercial nature of the transaction engaged in here, the relatively short period of time on the premises, and the lack of any previous connection between respondents and the householder, all lead us to conclude that respondent's situation is closer to that of one simply permitted on the premises. We therefore hold that any search which may have occurred did not violate their Fourth Amendment rights. Because we conclude that respondents had no legitimate expectation of privacy in the apartment, we need not decide whether the police officer's observation constituted a search.